How does separate property become marital property in New York? When couples enter a marriage, they often bring their own assets, savings, and property. In New York, the classification of these assets as separate or marital property plays a significant role in the event of a divorce. Understanding how separate property can turn into marital property is essential for protecting assets and ensuring a fair division. New York law distinguishes between separate and marital property, but under certain circumstances, separate property can be reclassified. Working with an experienced attorney is crucial to navigate these complexities and safeguard one's financial interests. The legal distinction between separate and marital property under New York law: separate property includes assets owned before marriage, inheritances, gifts from third parties, and compensation from personal injury claims. These assets generally remain with the original owner in a divorce. Marital property, however, consists of assets acquired during the marriage, including income, real estate, and investments, regardless of whose name is on the title. Equitable distribution rules apply to marital property, meaning courts divide assets fairly based on factors like the length of the marriage, financial contributions, and future needs. While separate property is typically not divided, it can become marital property if certain actions are taken during the marriage. Ways separate property becomes marital property: several factors can lead to the transformation of separate property into marital property. One of the most common ways is through commingling. When separate funds are deposited into joint accounts or used to pay for marital expenses, distinguishing between the two can become difficult. For example, if one spouse uses separate funds to pay the mortgage on a home that is jointly owned, a court may determine that the money contributed became part of the marital estate. Transmutation is another way separate property changes status. This happens when an asset, such as a house or a business, is retitled to include both spouses. By doing so, the original owner effectively converts the separate property into marital property, making it subject to equitable distribution. Additionally, the appreciation of separate property during marriage can be classified as marital property under specific circumstances. If the non-owning spouse contributed to increasing the value of an asset, such as helping to grow a business or funding home improvements, the appreciation may be considered marital property. The courts evaluate the extent of both spouses' involvement in determining whether the increase in value should be shared. Protecting separate property: to prevent separate property from becoming marital property, documentation and financial management are key. Maintaining separate bank accounts and keeping detailed records of gifts, inheritances, and premarital assets can help establish their original classification. If separate property is used to benefit the marriage, clear documentation is necessary to prove intent and ownership. Prenuptial and postnuptial agreements are also effective in protecting assets. These agreements specify how property will be classified and divided in the event of divorce. To be enforceable, these agreements must be in writing, voluntarily signed by both parties, and properly notarized. In cases where disputes arise over property classification, seeking legal guidance is essential. A skilled lawyer can help present evidence and argue for the appropriate classification of assets, ensuring that separate property remains protected. The process of property division in New York can be complex, particularly when separate and marital property become intertwined. If you are facing a divorce and need legal assistance in safeguarding your assets, the law office of Richard Roman Shum, Esq. can help. Contact us at 646-259-3416 or visit us at 20 Clinton Street, FRNT 5D, New York, 10002, United States to schedule a consultation.